where the parent company in its home jurisdiction. This is a key point in terms of something that needs to be considered, and that's why tax advice is so crucial at initial stage to see whether or not you want to set up a branch or a company, because there will be tax and accounting perspectives that need to be taken into account.
Greg, actually, I've got a question here, because in China, we have this distinction between branch and subsidiary as well, and often we have an issue in terms of paying corporate income tax, because very often, there's going to be a dialogue between the branch and whether the branch going to pay corporate income tax with this tax bureau, or have their financials consolidated with the parent and only pay the income tax at the parent company level. In terms of the branch in the UK, is it possible we argue with HMRC that we only pay VAT but not income tax, and because all the profit goes up to parent? Is that argument gonna work?
No, because you won't be able, or sort of a branch can't register for VAT. So for the guys who are listening, VAT is value added tax. And if you have an income, I think it used to be of about 80 or 90,000 pounds, it would be roughly there. You don't have to register for VAT, but if you often, as a standalone company, you do register for VAT, because that means you can offset the VAT that you charged. So, for example, we charge VAT to our UK clients. And if you're not registered for VAT, that means you can't offset that VAT. So what a lot of companies do is they do register for VAT, because that means that they can offset the VAT that they charged against VAT that they are charging, which means that it's not a cost. It's a transparent tax that just washes through. If you register for VAT, but a branch in the UK can't register for VAT. And what if you will be an entity in the UK, if they receive an invoice and it's a branch, they generally won't be charged VAT, because the entity that's being invoiced is an offshore entity per se. So they won't be able to charge. They won't be able to charge VAT, and they can't be charged VAT, and they won't be able to offset VAT if they are charged. They shouldn't be charged VAT because the nature of what they are. But they also wouldn't be charged corporation tax either, because their profits, the profits of the branch, would be filed, would be made known to Companies House in the UK, or the parent's accounts would be filed. But the branch itself would not be paying tax in the UK on its profits. Those would be paid back in, for example, China, the US, or elsewhere, as that entity would generally pay tax. Now we have the limited liability partnership, which is actually a creature of statute. Well, what do I mean by that? Well, there's a law passed called the Limited Liability Partnership Act 2000 that allows these entities to be formed, sets up what these entities are, the liabilities of these entities, how they formed, what governs their relationships. And this is, again, a separate entity, like a company. It's a separate entity to the partners who make it up, who are the members of that liability, the limited liability partnership. And what they do is the partners actually have a contract in place with the limited liability partnership. It's almost its articles of association, which is the limited liability partnership agreement or deed, that sets out the liabilities and the obligations of the partners in this entity. A limited liability partnership is different from a company from a tax perspective, because it's wholly transparent. So if a company will make profits, and a company pays tax on those profits, and if it wants to, it can declare a dividend which is paid to its shareholders. Limited liability partnership is very different. It itself, its profits form part of what its partners have. So its members its profits are attributed directly to its members, and those members pay tax on those profits. So again, when you're setting up these entities, it's absolutely crucial to understand what you want to achieve from a tax perspective and what the possible tax consequences of setting these entities up, or what they'll be. We also see these entities being set up to assist with getting visas, or tier 1 and tier 2 sponsorship visas. Very used a lot in those. It's not as well recognized. You know, when somebody's coming to the UK, we don't see people saying, let's set up a limited liability partnerships. These tend to be more specialist structures used for funds. So a lot in private equity, which I understand is different to how Chinese private equity works. But in sort of the UK, Europe, and the US, limited liability partnerships tend to be used within a private equity fund structure, is where we see these being used. Then we can jump to the next slide. Now, I mentioned other corporate entities when I first started speaking, and there are a number of different types of entities in the UK. We have limited partnerships. So what we were talking about was limited liability partnerships, was under the 2000 Act, but we also have LPs, limited partnerships. We also have a creature known as general partnership, and this stems from an act an act of 1907, which is the General Partnership Act. Again, this is a much more simple form of partnership. And if you're a professional, normally you see, for example, doctors, where doctors band together, they have a general partnership under the 1907 Act. Or if it's two people set up in business, they'll often use just this simply because they'll fall into that. They won't have thought about what they're doing. We also have something called unincorporated associations. So unincorporated, there's not a corporate entity. These tend to be, for example, sports clubs. Sports club is an unincorporated association. It's not a corporated entity. And actually our takeover panel, up until a famous case in the UK, which then put the takeover panel, making it a creature of statute, the takeover panel was an unincorporated association. And we also have something called the company limited by guarantee, which is a weird kind of a concept. So it's a company that's set up with a guarantee. So it's not a normal company as you would expect to find, with shareholders and limited liability for those shareholders. But what we see these companies being used is in the charity sector. So if you're setting up a charity, almost 100% of charity companies are set up as companies limited by guarantee. We don't see them being used in other circumstances, just within those. It'll just give you a flavor of the different types of corporate entity involved. So now we'll look at the corporate issues for a UK subsidiary and the type of things that you'll think about. The first point is, when you come to set up a company, all limited companies are registered at an entity called Companies House. This is an entity that's set up by the UK government. And the function of Companies House is to capture data about a company. And it's where you incorporate a company. So you write off to them to incorporate your company. And when a company dies and it's struck off or dissolved, Companies House does that. A key thing for us where we deal with Companies House, it's where a lot of information is filed. So in the UK, when you set up a company, you have to file its articles of association there. You have to file details of the directors there. You have to file details of the shareholders, who the shareholders are, where you and the number of shares that are issued and allotted. You'll also file, for example, if you change the articles, there are regulations in the Companies Act that say when you pass certain kinds of resolutions, you need to file these at Companies House. Why do we do that? So that people can track and see what the status of a company is. You can get details of its accounts. These are all filed online, so you can pick up details of the accounts, when they last filed them, So when we get a query where one of our Chinese colleagues will say, we have a client who wants to acquire a company in the UK, one of the first things we'll do is ask the name, because that allows us to do a company search to find out more about the company for them, to figure out how many employees does it have, what kind of assets, what kind of liabilities, and who controls the company. Because one of the things there is listed, a person with significant control needs to be listed down in terms of who controls the company. And this includes where if it's a state-owned enterprise. So we have a number of our clients are state-owned enterprises who incorporate companies in the UK. And we will say the person who controls it is the state-owned enterprise in China. There's a key aspect for us is this filed information. The other point is when you're starting a company, you'll ask yourself, well, what are we going to call that company? And the first point is, well, there are regulations which govern what you can call a company. Firstly, it has to, if it's an English private limited company, or if it's a public limited company. If it's PLC, it will have the words PLC or public limited company after its name. Or if it's a private company, it could have limited or LTD after its name. But the key thing is to choose its name, and its name can't be the same as another company on the list, because that name's already taken. And it can't be something that's offensive. So it can't be a swear word or something that's going to cause offense, because you won't be allowed to call that company that name. So one of the first things we'll do is we'll say to a client, well, can we please have 3 names that you'd like to call the company? And we'll see if they all those names are available. Sometimes the first name isn't available because there's something that's directly on point. Or maybe what we'll find is that there's actually a company with a very similar sounding name, and our client doesn't actually want to use that name because it sounds too similar to an existing company which does something completely different, but they don't want to cause any confusion with that company. But we are fairly lax in terms of that. I'd say we're much easier than the French, because if you incorporate a company in France, there are very specific names that you can have, and there are very specific names that you can't have, and you can't choose French names. You can't choose English names or any other names. If, for example, in France, you have to choose a French name for a French company. The UK is significantly more relaxed in terms of that. So the next thing you automatically think of, well, there's going to be share capital, because we're going to be owning shares in that company. So what are you going to think about? Well, is there a maximum number of shares that I can own in a company? Is the minimum number of shares that I own in a company? Can I only have one type of share capital? Can I have different kinds of share capital? And I think the point is there's no maximum share capital. You don't, in the old days, you had to have an authorized share capital. But since 2006, you don't even have to have an authorized share capital. You just have to say the number of shares that are issued. There's no minimum share capital. You can have one. You can have one share issued, and there's no minimum par value. So we've got a client at the moment who we're incorporating a company for, and they're incorporating a company with shares of 0.01 pence. So it'll be 100 shares will equal £1. So they're going to first set up with 100 shares of 0.01p, and the total share capital they'll contribute is £1, which is, it shows you the greatest degree of flexibility there is in doing this. We can have many different classes of share capital, which is great when you're dealing with companies that are venture capital companies. So when they're going to go through many rounds of capital raising. So in venture capital, you'll have, Series 1, Series 2, or sometimes they call it Series A, Series B, Series C. And each time we will have new investors coming in, and we'll issue a different kind of share. So I did one last year where we were up to Series D2. So we've done Series A, Series B, Series D, Series D1, and now we were doing Series D2. And each one of those shares had different rights. They were slightly different in one way or another. So it shows you the great variety and flexibility that's on offer to you here. As somebody, you want to set up a company, you can have voting, non-voting, preferred dividends, etc. It's only limited by your imagination, which sometimes is a good and bad thing. Key thing to think about is if you're buying shares, you will pay something that's underlined there called stamp duty or transfer duty. It's not done on issue of shares. So if a company issues shares, you don't pay any duty in the UK. But if you buy shares, just say you're buying shares for £100,000, you'll pay stamp duty at the rate of 0.5% on that £100,000. You'll need to pay tax on that of 0.5%. So it's not a huge amount. It's just something to be concerned or to be aware of if you buy shares in a private company or a public company in the UK. You generally pay stamp duty unless it's sort of below £1,000. Or what we find is when we reorganize companies, we're doing company reorganizations. We just did one for a large Chinese group where they move companies around. So one company buys another company in the group. You get group relief and no stamp duty is payable. Again, from that perspective. Another thing you think about, so we've thought about, what you're going to call your company, the share capital, and you think, well, who are my directors going to be? What is the position of directors in a limited company? Again, UK, fairly flexible. You do need directors in a UK company. Normally, you'll have more than one. Where you have more than one director, they tend to act collectively as a board of directors. But a director, saying that you can act as a board of directors, but a director in a UK company can bind a company. And we're seeing this now where we're acting for a Chinese client, and he's a director and a shareholder in the company, and he's suing his other directors because what the other directors did was they went and they entered into agreements on behalf of the company, which they did, but they didn't have authority to do that. But they could actually make the company bound by those agreements because they signed those agreements in the company's name. He wasn't aware of these details, but what they did is they bound him as a director, and he's now taking action and suing them because he didn't want them to do that. They didn't keep him informed. So it's something to be aware of. When you become a director in the UK, your other directors can still bind the company because they have something known as ostensible authority. When they're dealing with somebody will think because they're a director that the company has the power, that director has the power to bind the company. A great thing about being a director in an English company, you don't have to be English. You can be Chinese, American, Australian, whatever. You don't have to be English. You don't have to have an single English director, which is different for example, the Netherlands. If you're setting up a company in the Netherlands, in Holland, you need one of the directors actually has to be Dutch. In the UK, that's not the case. Anybody can be director of an English company. What it becomes important for is, again, it's a tax question, is saying, is everything the company doing in the United Kingdom, or is it being done elsewhere? Should it be taxed elsewhere? Different question. But there's no limit on who can be a director from a nationality perspective. Again, no limit on the number of directors, although from a number perspective, you don't want it to be too many because otherwise it becomes just administratively and practically difficult in terms of managing. We can still have corporate directors in this country, in the UK, although there were talks about this changing. It hasn't been legislated yet, but we expect this will change. Exactly when, we don't know. But at least one director must be a person, but we can still have directors who are corporates. So you can have a corporate vehicle who is a director of a company. Again, very flexible. That's the point I mentioned about corporate directors. if you have more than two directors, one of the directors will be appointed as the chairperson, chairman, chairwoman, and sometimes that the chairman is given an additional vote. Doesn't have to be given that vote. If there's an equality of votes, sometimes the chairman is given a vote to break that deadlock. Sometimes he isn't. But at board meetings, the chairman will preside, so the chairman will lead the meeting, and also at a meeting of shareholders, the chairman will lead the meeting of shareholders. But that's the main function of the chairman in the UK. Okay, next slide. Now, board meetings, in terms of how directors meet,
Just give me a second. 那个我不知道那个是不是可以方便那个有同学通知一下这个华为的这位同学，让他把手机闭上。OK 了，好，请大家那个如果不问问题的话，保持静音啊，那个多谢啊。Yeah, sorry, Greg. Yeah, go ahead. Yeah.
Thanks, Ray. Now, board meetings are important because this is how the company is constituted. It's corporate governance of the entity. And so while the only formal requirement is to have a board meeting at least once a year, generally, to approve the annual accounts, where the directors approve the annual accounts, and it can be a written resolution, it's usual for a company to have board meetings at a regular frequency, whether or not that's once a month, once a quarter. But it's from a lawyer's perspective, we like companies to have board meetings at a regular interval, whether or not it's once a month or once a quarter, where they look at what's happening in the business. And the frequency of board meetings is normally included in the articles of association, which we'll come to. But this is where it sets out the frequency that board meetings take place. Where you're doing a joint venture, for example, where a number of shareholders come together and establish a company for doing business, what they will put in the articles of association is how often the board can meet, who needs to be at board meetings to make decisions. So if there are a number of shareholders, they'll often say there has to be a director who's appointed by the A shareholders, the B shareholders, and the C shareholders, who have to be at a board meeting for a decision to take place. So it's really important that these are focused on and understood. Board meetings can take place by telephone or video conference. This was especially important during COVID, where people couldn't meet. And you can even say where that meeting is supposed to have originated from. So you'll remember that I said where it has a tax consequence as to where a board meeting's taken place. And sometimes you want the board meeting to take place in the United Kingdom to make sure that it's going to be taxed in the UK and maybe not taxed elsewhere. So you'll say the video conference will be deemed to have taken place in United Kingdom, in London, or wherever the chairman is, because that helps establish where that entity will be taxed. It's just something to bear in mind in terms of where it will be. How are directors appointed? Generally, they're appointed either by shareholders, by resolution of shareholders, or often, as is the case, directors, the current directors of a company, can generally pass a resolution appointing directors. Where a director is appointed, there'll then need to be corporate filings, which go to Companies House, which we mentioned, so that if I do a search, I can check that Herway is a director of KWM, for example, and I know that he can bind KWM, and I can check he's still a director. I can see where he was appointed, and it gives me comfort that I know who I'm dealing with in terms of who's at that company. Okay, next one. Now, in terms of board meetings and directors, we often get asked the question, can my child be a director? And we often say, well, how old was your child? And sometimes the child is under 16. People under 16 can't be directors of companies in the UK. If they're older than 16, they can be, and we've done that for some clients who want their children as directors of companies. as is often the case. The key thing to remember, there's no free lunch. And what do I mean by that? If you become a director, you have certain duties and obligations which are imposed upon you by the Companies Act 2006. That means you have certain statutory legal duties. And these duties are owed to the company, to your other directors, to shareholders, and to other stakeholders. These could be creditors, people who do business with the company, customers, employees. That's who you as a director owe duties to. So you've got to bear in mind that, and you have to act in a way that's not going to bring you in conflict with any of these or leave you open to being sued. So somebody, if you do something wrong, a shareholder could potentially bring an action against you as a director. You always have to bear that in mind. An employee can bring an action against you as a director if you do something wrong, or a customer. So you keep on buying goods from a customer, knowing that the company is in trouble and you'll never be able to pay the money back. That actually is an offense. You as a director will be liable for that, and you may have to pay that customer back out of your own pocket if you fail the relevant test. So these are the things to be borne in mind when you become a director of a company. Company secretary. We often ask, does a company need a company secretary in the UK? You can have one. You don't have to have one. You no longer have to have a company secretary. It's often very useful to have a company secretary. And there are organizations that we work with that act as secretaries for companies that are established in the UK for our clients. What does this mean? It means that they keep the minutes of the meetings, they send out the board papers, they draft the resolutions, they make the filings at Companies House, they file the accounts every year at Companies House. It's very useful for especially companies that are owned by either foreign companies or people not in the UK, with shareholders are outside the UK, to have a company secretary in the UK to do filings. Again, you don't have to be a UK national to be a company secretary. You could be a Chinese director who's the company secretary, and we have a couple of those amongst our clients, and they make the filings, but then they know what they're doing. But it makes it easier for the person to have a person in the UK to do the filings if they're not familiar with it. But it's not an officer that you have to have. Registered offices. All UK companies need to have a registered office, and the registered office needs to be in the UK. You can't have the registered office in Beijing, Shanghai, Guangzhou, anywhere else. It has to be in the United Kingdom. And what this does is, where the Companies House sends you information, it'll send you the information at the registered office. If people want to send you notices, statutory demands, or if they want to bring proceedings against you, they serve notice at your registered office. What we often find is that those people who employ a company secretary or an organization to be their company secretary, that organization will also give an office address for that entity. It will say it's this address or that address. That it allows them to have an office in the UK if they don't really have a physical premises in the UK. It allows that to be. We also find there are a lot of companies who have offices in London. They're very prestigious addresses. For example, Mayfair in London is quite a prestigious address. And there's a nice square in London called Berkeley Square. I'm sure Wayne knows it well. Now, Berkeley Square is very posh. People really like that address. And there's one company secretary that has one office in a rented building on Berkeley Square. And they have thousands of companies that have a registered address at this office in Berkeley Square because it's such a prestigious address. Those companies don't own any office space there. They own nothing. Not even the registered agent owns any office space there. It rents an office, which allows people to have this prestigious address. So you always think, well, is a company there where it actually has the address? You'd always ask that question. Okay, constitutional documents. You heard me mention the Articles of Association. Well, articles of association and memorandum of association are two key documents. Memorandum is an old quirk of fate, goes back into the dim, distant English history. It just tells you who the subscribers, who the initial people who own shares are. It doesn't have much purpose around that anymore. Articles of association, on the other hand, is absolutely key. Why is it absolutely key? Because this sets out the contract between the company and its shareholders. So everything relating to the company and its shareholders are set out in the articles. Now, the Companies Act 2006 has a form of model articles. So if you don't want to really think too hard about it, or you want to adopt something that has been used and you know works, people adopt the model articles. We'll use the model articles. They're perfectly good for a single company. But if you are setting up a joint venture or a company where a number of people are investing, you and your friends have got a new company, you want to sell a new project, you each put money into the company and you're each going to have shares. That the articles of association then become really important, because that's going to set out how often you have board meetings. It's going to set out how your shareholder meetings are held. It's going to set out what your quorum. Remember, I said, well, what's the quorum for a board meeting? So how can a board meeting take place? So who needs to be there for it to take place? Does it have to be all shareholders, or or by shareholder nominee? Just say I hold A shares, Herway holds B shares, but I don't want a board meeting, or Herway doesn't want a board meeting to happen where our directors aren't present, and each of us, the A shareholders and the B shareholders, can appoint a director. So what we'll say in our articles is that a board meeting can only happen where an A director and a B director is present. So to think about it is that you really want to give thought to what goes into your articles of association, because these are pretty key documents. And then if you flick down, these are the type of things that go into your articles. Your dividends. When are you going to declare a dividend? Will there be a dividend of a specific amount? Will all shareholders get equal dividends? Will you be able to sell shares? Will Herway, if we go into a company, will Herway want me to sell my shares to my best friend? Or will Herway say, no, you first have to sell the shares to me first, offer the shares to me? Absolutely crucial things. Will we both have voting rights? If another investor comes in, do they have to, will there be anti-dilution rights? How will transfer of shares generally work? Will we give shares to employees? These are things you've got to think about. And these are the provisions get put into the Articles of Association. So it's absolutely crucial that people give thought to what goes into the articles, because they set out rights going forward. Now, taxation, to me, taxation is actually the most crucial part whenever you're setting up an entity in the UK. You should actually ask the tax question. And we say to our clients, think about the tax question before you even think about the entity that you want in the UK, because tax will inevitably it will decide what type of entity you need. It will decide who is going to be in that entity, the type of shares will be in that entity, how much equity, how much debt you put into that entity. So by equity, it's like, will you buy only shares in that entity to put money in, or will you loan that entity money? That's the debt ratio of that. All of that's highly crucial and will have a tax bearing. Why? And because that means once you establish a UK company, that UK company will become subject to UK corporation tax. That means because when you trade and start making a profit in the UK, that profit will then be taxed in the UK, because you've established a UK permanent establishment in the UK. And the tax position for a company means that you pay tax. You may or may not register for VAT, but if you start employing people in the UK, one of the things you'll need to consider is pay as you earn tax, payroll, whether or not you become VAT registered in the UK. You'll recall that we spoke about VAT earlier. One of the questions you'll say is, well, should we become VAT registered? Not all companies are VAT registered. You don't have to be. It's just a decision as you start trading and becoming more profitable, and depending on where your business is this something that is useful for you to do? And also when you start entering your company in the UK, may then establish subsidiaries in China, it may establish subsidiaries in Europe or United States, and then the tax issues become more interesting and more complex. And ultimately shareholders are interested in this because the profits of the company, once they've been taxed, can be distributed to the shareholders. So you as a shareholder have a very keen interest in what those profits are and what those profits are, how they're taxed, because you as a shareholder are going to get a dividend on those. So you'll want to understand that. And that's why companies always want to understand what the tax benefit or tax advantage or just the tax situation is when you're establishing a company in the UK. Employees. Now, in the UK, we have our employment is contract-based. They're very different to if you've dealt with companies in Germany or France or any one of the continental countries. But we have a very different way of setting up our employees. And our employees have certain rights automatically, depending on how they're employed. And that we've got three broad categories of people you employ. And this is something that we always tell companies when they're coming in, is you've got to figure out this early in terms of how you want to employ people. You've got employees, you've got workers, you've got self-employed, which are generally contractors. And depending on which category people fall into, they will have a separate employment contract. And they will have separate protections in law. So if you're an employee, then you have a lot of protection as an employee under law. Under general law in the UK, you have a general level of protection, and which means you can't just be fired, you can't just be unfairly dismissed. Unlike Americans, when we deal with American clients, when they buy a company, they say, yes, we'll change the workforce immediately after we buy the company. And you go, well, in the UK, you may be able to do that in the US. In the UK, you can't do that. You've got to consult with people. It's not as bad as if you do something in Germany where changing the workforce is almost impossible. In the UK, you can change the workforce, but there's a process you need to understand in order to go about doing that, and understanding the flexibilities within the system and in terms of how that works. If our self-employed people or independent contractors have very little rights because you're self-employed or you're an independent contractor. A lot of industries employ independent contractors. So, for example, in the TV and broadcasting space, in the taxi world. So, if you've got companies like Didi who set up drivers, each of their drivers generally will be regarded as an independent contractor. They'll have a little bit more rights than independent contractors, but generally they're independent contractors who tend to work for themselves. Same when you work for a TV, you work for the big broadcasting companies. You tend to be an independent contractor, so you don't have those employment protections. So you won't have certain protections about being fired, unfair dismissal, or holiday pay. But bearing in mind the UK, you've got to think about this when you employ people. There are certain minimum protections. So, for example, if you hire people, you want to start selling clothes, and you start a clothing shop and you set it up in Oxford Street, there's a national minimum wage. So there's a bare minimum that you actually have to pay people. There's a maximum working hours that you can tell people to work, especially if they're under 16 or 16 and above. They can't work for more than a maximum period of time. You've got to give people paternity and maternity leave. So when somebody has a baby, they get if it's a lady, she gets maternity rights. Fathers now get paternity rights. So these are rights enshrined in law in terms of what you have. And you'll find large companies in the UK tend to offer very similar benefits. So what that means is that the employee benefits, you'll get holiday, you'll have a right to contribute to a pension, you'll get sick pay. So if you are sick, you'll generally get paid for that. They offer health insurance and various other perks in terms of those. And that's just what companies in the UK tend to do in order to create a competitive workplace for why people want to work for them. When there's something that's mentioned there called TUPE, which is a strange beast. And TUPE stands for the Transfer of Undertaking, Protection of Employment Regulations. So what does this mean? And we see this where we do deals for clients where they are buying assets. So you're not even buying a company. You're coming to the UK and you're buying assets. You're buying machines. Just say you're a car company and you're buying car assembly machines. Now, TUPE will say, well, the people who work on those machines will come with those assets. So you always need to think, well, if I'm buying assets, are people coming with those assets? Because you will automatically be deemed to actually be taking those employees as well on their current terms. But what does on their current terms means? It means that you'll be paying them the same salary, giving them the same benefits, and employing them on the same basis as they used to be employed when they were working on those machines for somebody else. Just something to bear in mind. We always tell our clients that there's something to be borne in mind. This applies throughout the European Union, actually, but it's not something that US companies are aware of, and I'm unsure whether it applies in China, but it definitely applies when you're buying assets in the UK or Europe. It's just to bear that in mind that comes up. And you can't just fire people straight off. When you buy a company, you can't go, we're firing the workforce tomorrow, or we're firing 30% of the workforce tomorrow, because people will have minimum protections in terms of periods of notice, leave, in terms of how that's all done and needs to be factored in. Or even if they're being made redundant, there's certain minimum payments, sometimes not huge, but they just need to be borne in mind and factored in. Okay, next slide. So you've got your company, you've set up the share capital, you've got your directors, and now you're saying, well, okay, we need office space. What do we need to do? So the UK, in terms of real estate, and real estate, I mean land, there are a number of different options for companies. Depending on your needs, what you want, what you're getting out of it, how long you're going to be in the United Kingdom, it's fairly flexible. So if you flick onto the next slide, you'll see the potential optionality. So we've got long-term locations. So you know you're going to be here for a while. You want to shop in Oxford Street for at least 12, 24 months. Or maybe you want your office space for a few years. There we have something called freehold. Freehold is where you own the land. So you own the land, you can buy the land, and you will own it forever. And so you can own it forever, or you could until you decide to sell it. And you'll be registered as the owner of land. Or if you want to, you can buy leasehold, where you buy you don't buy the land itself, you rent the land. You buy a period of rental of the land. And that can be for a very long time. The longest lease in the UK is 999 years. Sure, you can get leases for 12, 24 months, 37 years, any period in between. Much shorter location, if you're just thinking, well, no, I just want a WeWork office. Yes, we have WeWork in London, as well as other places where you can do offices on very short let. Maybe you only want an office for 2 hours a day, or maybe 2 days a week. You can do that. And you can enter into an agreement that deals with that. You can also, we work as a co-working place, for example, a co-working place where you'll have a number of startups all working within like a large space, which has become very popular in buildings in London at the moment, as especially during COVID, landlords have sought to maximize their rent, and so are offering co-working spaces. And that's what we call a license to occupy. A license is not the same as a lease. It's a less of a right in terms of it, but again, it's a type of agreement, type of right to occupy those premises to do what you want to do. So those are your options in terms of different kinds of office space. And then real estate costs, which is just the next slide. When you buy real estate in the UK, yes, you pay tax on it, like anywhere else. It's something called stamp duty, land tax, where you pay tax on. And that's just to be aware that you do pay stamp duty on it when you buy resi on houses. Just think about the tax that you want to pay. Well, I'm not sure if it works. Should we jump to considerations when acquiring a business in the UK?
Yeah, I think so. Yeah, and I think we've got roughly about 25 minutes and probably give people some time
to ask questions. Yeah.
Yeah. Okay. Yeah.
So considerations when acquiring a business in the UK, and this is the one we see most often, because this is what our clients need to think about. So if you flick to the next slide, when you're buying a company in the UK, key thing is something called due diligence, which I'm sure a lot of you are aware of. It applies wherever you're buying a company. But why is it particularly important in the UK for foreign buyers? It's important because the regime in the UK may well be different to the regime that you're used to dealing with. And the liabilities that flow from that, both from a statutory perspective, but also from a contract perspective. If you're buying a company that has a lot of contracts, you have to understand those contracts to make sure that you're not buying a whole host of liabilities. You want to understand how those contracts will impact the company that you buy, the contractual relationships going forward, how you'll make money, or is it going to be a loss-making venture? You'll also want to understand the nature of the corporate structure you buy. What is the company? What is its shareholding? What are the rights set out in the Articles of Association? Is there a shareholders agreement? You'll want to see whether or not they've got bank finance in place. Because one of the things we mentioned at Companies House, a lot of things are filed at Companies House, including bank charges. So if a bank takes security against an asset and they perfect that legally, that charge has to be filed at Companies House. So you want to look at this, and all that areas on the slide are areas you'd want to look at and focus on. I think it's no different to where you're doing a deal in China or the US or France, Germany, South Africa. These are the areas you want to look at, because when you buy the company, you'll want to make sure that there's no liability lurking in any of these areas, which is going to mean that you suffer a loss after you've acquired the company. Now, UK merger control is relatively benign. It is looked at. So benign, what I mean is, if you're a large bottling company and you're acquiring another large bottling company in the UK, and you are going to consolidate competition in the UK, or for example, you one TV company that's going to take control of another TV company, then the regulatory authorities will look at that, because they'll want to make sure that there's not a consolidation or concentration of interests, which is going to be bad for consumers or indeed in a particular industry. And the organization that monitors that is the Competition and Markets Authority. And the CMA will actually look at things, but there are thresholds that are set out that people can look at in terms of doing it for the larger transactions. Generally, these are triggered by larger transactions rather than our run-of-the-mill transactions that we do every day. But it's something to be aware of. If you've got particularly a company that's got a very large interest in a particular sector or has a lot of interests in a sector, then one of the things that should be in your back of your mind is there merger control? Is it going to raise competition aspects for that company on the buy side or the sell side? Because you may need to make a filing to get authority to actually proceed with that. Of more relevance is actually the next slide, which is the National Security and Investment Act 2021. Now, this is a very new piece of legislation. It only came into force last year. Very new, but particularly relevant for companies that are buying into certain sectors in the UK. So what this allows, it allows the Secretary of State for Business, Energy and Industrial Strategy to intervene and look at qualifying transactions or qualifying acquisitions. Now, generally, a qualifying transaction is a transaction that takes place in one of 17 sensitive sectors in the UK. And the 17 sectors are set on the next page, on the next slide. So if you're a company who wants to go into advanced materials, I'm not sure if some of you guys may or may know something called graphene. Graphene is, for example, an advanced material, but there are other materials like it. Or advanced robotics, cryptographic authentication used in payments, or, for example, a whole host of other mechanisms, data infrastructure, military dual use, so something that can be used in military or non-military, satellites and space. Any one of these sectors that becomes relevant, the government is likely to be interested in this transaction, where you have to make a mandatory filing if it's a qualifying transaction, which will be on the next slide. So in terms, well, yeah, it's not there, but if you acquire 25% or otherwise have control of an entity in one of these 17 sectors, then you have to make what's known as a mandatory filing in terms of it. Now, we've seen a few mandatory filings. We've also seen the government stop transactions in some of these 17 sectors because they don't want those transactions to proceed. I've actually seen, and I've done an opinion recently on a transaction that was filed, and the government said, sure, we don't see any problem on it, and they've carried on, and that transaction has happened. I'm in the process of giving that opinion, where the BEIS Secretary of State has confirmed he has no problem with it. It's not in the 17 sectors. People were worried, so they made a notification, and the government said, actually, no, don't worry about it. Please proceed, do your acquisition. But the thing to think about, which is going, and this is, I think, not dissimilar to the process that's happened in Europe, the States. I think everybody's put in National Security Investment Act screening in certain sectors. But I think the key message here is, if you don't fall within those key sectors, the UK remains very much open to business, and transactions are proceeding, as I've seen in this one. But we are doing a fair amount of work in this area at the moment, advising companies who want to make acquisitions of companies in the UK.
Yeah, but Greg, I think we do recognize that there have been quite a number of China-related transactions being either rejected or subject to conditions in the past year or so. So I guess two general questions. One is that are these, rejected or conditional approvals largely fall into the sensitive sectors? And for two, if there are future these investors looking at these potentially sensitive sectors, how do we tell them? Is there still a possibility of getting the deal through? Compared to what you see
to what it was before.
Yeah.
I think it's actually, you mentioned Chinese investors. I was just reading, because they're starting to come out stats now. I'm waiting for the BEIS paper, which will it's due out now in terms of their last year, because they've also it's not only Chinese deals with Chinese buyers that have been turned down or put conditions. There's also been a couple of other sort of nationalities, and not Russian or anything like that, but where they've turned down as well. From that perspective, I think if you fall, my reading on it, if you fall within one of those sectors, depending on the sector itself, they will either put conditions on it and say you can do this, but you need to put screening in place, which I think we've seen on a couple where they've said you've got to hive off certain information for it to happen, and they've done that. Or because it is regarded as just sensitive, they won't allow anybody to acquire that, whether or not it's Chinese, American, or whatever else. They actually won't allow it to happen. So I'm seeing a company, I'm dealing with a company with semiconductors at the moment, and it's got Chinese investors in it. It's got 3 Chinese investors in it. I think which were all not a problem, but when they wanted to move their operations to China, in terms of manufacturing the chips to China, and that transaction was blocked, which was interesting because you're then taking the manufacturing capability out of the UK, and they said no, we want the manufacturing capability to remain. So I think it'll remain to be looked on a case by case basis. But I think if you look at the type of the type of industry and the application in the industry, whereas I think some applications within an industry will be allowed, whereas some applications won't, and it'll be just it will be and not national security. I think it will be security interest in terms of whether or not the UK wants that entity to remain in the UK to try and get that business to grow in the UK as opposed to be taken out.
Yeah. I think that just wraps up what Greg's presentation, regarding possible investment in the UK. I know we are running short of time. I'm probably not gonna go through the China's regulatory regime in details, and we'll share the presentation with students and they can read themselves. I guess we'll probably just pause here. And Greg, I think some students, might have questions, but not necessarily, be able to speak in English. So maybe just let's pause and ask them if they've got any questions, and we'll try to answer them.
Sure, Chinese questions in Chinese are great as well.
行，那我觉得同学们今天我们大概花了1个小时15分钟的样子吧。从公司设立到税务资产，还有就是收购英国公司涉及到反垄断申报，还有这个最新的英国国家安全审查，我们都做了一个基本的介绍。那最后一个部分，中国的这个境外投资，考虑到时间有限，那我就不更多介绍了。那我相信最后一部分是中文撰写的这个 presentation， 大家可以课后的来看一下。那我觉得我现在就是想问一下大家，就是对于前面的这个英国公司法的一些基本的制度，还有中国企业来英国投资涉及到的政府审批这部分的话，我在聊天里面我看到大家可能希望提一些问题。那如果有问题的同学，我想现在可以一些时间。我能解答的我就用中文解答了，我解答不了的话，请 Greg 来帮我解答。因为考虑到时间有限，我们这次没有安排就是逐字逐句的这个中文翻译那这个 presentation 我们可以会后提供。那如果明年我们再来做讲座的话呢，我们也可以做一些调整，然后给同学更多的这个中文的内容吧，好吧？那看看大家有什么问题。我记得刚才好像有几位同学在群里面说，好像是要提问的。现在有没有问题提问？刘律师，你还在吗？在现场吗？刘新宇律师在吗？
何律师，我在现场。
在现场的同学没有其他的问题了是吧？
现在没有同学有问题。 何律师，现在有一个问题问到了一个，您看到了吗？
英国政府只允许中企对什么投资、怎么投资，永不允许怎么投资。这个问题我先解释一下。Hey Greg, I think I think one student raised a question regarding the UK national security review. I'll try to clarify and if there's anything I can't answer, I'll translate. 这个英国的这个国家安全审查呢，实际上应该是在2022年1月份开始实施的。刚才 Greg 也提到了，在我们的 presentation 第43页涉及到第43页涉及到17个敏感行业。这17个敏感行业呢，这个如果说涉及到中国企业投资的话呢，确实呢有一定风险。我们在去年呢看到英国政府否决了5项投资，其中有4项是中国的。4项中国投资呢，基本上都是在这个科技领域，应该涉及到advanced materials 或者是 computer hardware， 应该都是 IT 行业的。然后另外的话呢，可能还有8项到9项交易呢是批了，但是的话是有条件批准。所谓有条件批准的话呢，它可能会对你公司董事的任免包括这个公司这个要把这个主要的运营保留在英国它会设定一系列的条件。所以我觉得呢，就是说刚才跟 Greg 也在聊这个话题，就是说未来的话呢，如果是涉及到这17个敏感领域的，不是说一定批不了，因为我们也看到有很多批了，或者有一些是附条件审批。但是这些的话呢，可能要花更多的时间跟英国政府呢，可能要做一些事先的沟通那当然是有这个不批的风险比方说晶圆厂或者说一些高敏感的这些是有可能是批不了的。除了这17个敏感行业以外，其他的行业总体来讲，英国对中国投资人的这个态度，我觉得呢是比这个美国是要好一些的。比方说地产、教育然后新能源，在其他行业呢，其实我们是看到中国企业还是持续的在英国投资的然后呢，而且也不涉及这个英国的国家审查所以我觉得这是大概一个情况。我不知道有没有回答你的问题。
好的，那如果没有什么问题呢，何律师呢，我们今天可能也到下课时间，那就到这里。
好的。Yeah, Greg, I think that was pretty much the end of the presentation. And Greg, thank you very much. I guess we'll see the students next year.
Sheshe, thank you. If you've got any questions, do let me know.
Yeah, 好，谢谢大家谢谢。
Sheshe.
Thank you.
Bye.
Thank you. Bye bye.